COPAC was after a long struggle, with trying to get a people-driven democratic constitution. And the opportunity presented itself with the signing of the Global Political Agreement. Section 6 of the Global Political Agreement then provided for the establishment of a Constitution Parliamentary Select Committee, which later became known as COPAC. It was very, very important as we started to draw a roadmap or a vision of what type of constitution we wanted. We wanted a constitution that would make Zimbabwe a constitutional democracy. We wanted a constitution that would guarantee human rights, curb excesses in the exercise of power, introduce term limits to our the holders of state and other responsibility, and guarantee the rights of women and youth. That was the constitution that we were looking at. And I'm happy to say, despite the difficulties that were there in crafting this constitution, we were able to produce a constitution which is one of the best in the world, objectively speaking. We have a constitution right now which is one of the most comprehensive Bill of Rights on the African continent. It does guarantee Zimbabweans quite a lot of rights. For example, I heard last week that Parliament is going to be interviewing people for the position of the committee, the Independent Complaints Commission. This is a commission that is going to hear complaints specific to members of the security services. Members of the public, if they are violated, they go to that committee to complain about the behavior of the armed forces. And this is very, very important. So on paper, yes, we had independent institutions, ZEC, the Gender Commission, the Human Rights Commission, etc., the Chapter 12 institutions. Those are supposed to guarantee democracy. We have limited term for the president. For other officers and other commissioners, we have a limited term of office. It is a very progressive constitution indeed. There have not been political will on the part of the ZANU-PF government to implement this constitution. The tragedy is that of those things that ZANU-PF did not agree with during the constitution making process, but was overpowered by the people, it has been slow to implement. Devolution was agreed as far back as 2013. It has not yet been implemented as we speak. We of course have ministers responsible for devolution with no devolution taking place. This is not just devolution, it's devolution of power. So it hasn't been aligned to the constitution. The independence of the Chapter 12 institutions has been abrogated. First of all, just as an example, the Anti-Corruption Commission investigated during Mugabe's time, investigated ministers, including Minister Kasukuwere and other ministers. When they go to the offices, they were met with AK rifles. So the ministers were able to mobilize state power to resist an independent commission. And nothing really happened to them. The independence of ZEC, right now, the state retains the power of the purse over the Zimbabwe Election Commission. It is not completely independent. It is populated by people who are from the security services and from the executive, in the secretariat and the key subcommittees of the Zimbabwe Election Commission. So on paper, yes, it is there, but in practice, nothing is happening. So that's the tragedy of Zimbabwe. We have a good constitution, but we do not have the practice of constitutionalism, by which is meant having a written constitution and following that constitution. Well, one of the unwritten things about a constitution is that it must be very, very difficult to amend. And it must not be amended at the whims of the ruling party or in order to please a family or an individual. So the amendments that are being proposed right now amount to a decimation, mutilation, or evisceration of our constitution, or removing the bowels from our constitution. That's what these amendments amount to. First of all, there's this amendment about increasing the term limit of President Mnangagwa by another term. The president, of course, has come out refusing that. But he cannot refuse that members of his party are pushing that agenda. Some members of ZANU-PF are pushing that agenda. Members of the Youth League of ZANU-PF, members of Masvingo province of ZANU-PF made clear pronouncements that President Mnangagwa must be given a third term. And this is the way of ZANU-PF doing things. We know it throughout history. They put people to test the waters. So that amendment is a retrogressive amendment. It will destroy what we were trying to build. We were trying to avoid despotism in this country, totalitarianism. We are trying to avoid a person who is given state power but then overstays in power. We saw it, and Zimbabweans need not to be reminded about what they went through. The second amendment is that it looks like a Plan B amendment. And this amendment is that the presidential election as we know it is not going to be there anymore. We are going to have an election of the president by parliament. In other words, people vote for members of parliament, vote for a party, and then after that, the parliament sits and elects a president. In other words, whereas the president is elected under the current system, is elected by the generality of the Zimbabwean population, and therefore has executive power. The proposed amendment will mean that the president will be elected by 350 people. That is an affront to democracy. Now, if ZANU-PF really wants that, wants a situation where the president is elected by parliament, just like the situation in South Africa, they must be prepared to then go with a constitutional amendment that then puts the South African electoral system, not the Zimbabwean electoral system. The South African system is first past the post, is proportional representation, whereas the Zimbabwean system is partly first past the post and proportional representation. Under the South African system, therefore, people vote for their political party, and then when the MPs are now in parliament, they vote for the president. That is a continuation of proportional representation, actually. Now, in Zimbabwe, we have first past the post for the majority of the constituency MPs. For the majority of the MPs, all the constituency MPs, the 210 of them, are elected by the first past the post system. You cannot have first past the post system in electing MPs and then a different system in electing the president. That simply doesn't make sense. But there is no need for that amendment. It is simply amounts to desecration of the Constitution. The third amendment involves removing voter registration powers from the Zimbabwe Election Commission, an independent institution, to the Registrar General's office. Remember, under the Zimbabwean Constitution, the Registrar General is appointed singularly by the president. So, in other words, indirectly, the president, under the proposed amendment, will be responsible for voter registration to be used to generate a voters' roll to be used in an election where he will be contesting or his party will be contesting. Clear conflict of interest there. It's also retrogressive. Remember, the Zimbabweans were moving away from the days of Toba Mdede and that system. Zimbabweans rejected it in 2013. Now, if we then go back to the Registrar General being responsible for the voters' roll, we are going back to what Zimbabweans totally and unequivocally rejected. The last amendment that we hear is that they want to remove delimitation functions from the Zimbabwe Election Commission to what is called a delimitation commission. Now, a delimitation commission is nothing new in Zimbabwe. It was there in the 80s and the 90s, and the delimitation commission was appointed by the president. So we will have voter registration being done by a direct appointee of the president. We will have the delimitation commission being headed by the person directly appointed by the president. In other words, we are going to have a president with the powers of election or of elections over the election system, and that is not acceptable at all. Zimbabweans must reject this. This is going to send us back to the pre-2013 era. The pride of Zimbabweans was its constitution, and if the amendments are allowed, then we have no constitution to talk about. It is very difficult to generalize. I know that there are men and women of integrity who are manning our courts. Some of them I have worked for years with them, for 34 years now, and I can vouchsafe for their professionalism and integrity. But yes, there are times where political considerations are put in deciding court cases. There are times when the executive is clearly seen to be overbearing on the judiciary, and that ought not be the case. Zimbabwe is a country which must have separation of powers among the arms of the state, the judiciary, the executive, and the legislature. The judiciary must be left to do its job. I was quite impressed by the courts in Kenya, the courts in Malawi, the courts in South Africa. They have separated their personal political preferences with their professional duty. Just last 2 weeks ago, I think, they ruled against the attempts to bar the MK party. I think the party that President Zuma is fronting right now. The ANC wanted that party not to be registered to participate in elections. The judiciary said no. We had in Kenya election, the election before the last one, where the judiciary was given evidence that the election had been stolen, and they nullified the election. The next challenge, they looked at the case on its merits and ruled in favor of the winner. The Malawians did it. I think when President COPAC came in, it was after a legal challenge of the loss that he had suffered at the hands of President Wamtarik at that time. So I think the other countries have done well when it comes to the judiciary. We are yet to match other countries. And the reason is that our courts, our constitutional court, is over relying on technicalities when they decide cases. They must move away from there, from dispensing procedural justice to dispensing substantive justice when it comes to matters of this nature. Xavier Kasukuere was barred because of the residence requirement within the law, and there the law says he must have been in the country for a certain period of time. The judges didn't look at whether or not he had reasonable grounds of not coming to Zimbabwe. As we all know, Kasukuere was facing persecution, political persecution, and he actually says that he feared there were threats made to his life. And under those circumstances, the courts must have invoked a doctrine, and this doctrine is called the doctrine of fictional fulfillment. And roughly what it says is that if I'm obliged to do something and you make it impossible for me to do it, then the law says I have done it. So just as an example, if you are an employer and you lock the doors and I'm unable to come and work, the law says I have worked. So the doctrine of fictional fulfillment, it applied in Kasukuere's case. But we all know that Kasukuwere was bad because the system did not want the split of the ZANU-PF vote. It was felt that Kasukuwere would take the vote, the ZANU-PF vote, mostly in the Mashonaland area, especially Mashonaland Central, where he hails from. And it was wrong. These are some of the things that we want reforms on. Zimbabwe now has dual citizenship in the constitution. So if you are allowed to be a citizen of Great Britain and a citizen of Zimbabwe, it must not really matter where you are staying between the two countries. Your rights are unaffected. So if you then say you must have been in Chinamora for the past 18 months for you to be president of the country, that is wrong. So it is one of the things that we are going to be looking at during the electoral reforms. In other words, disqualification of candidates must not be acts of vindictiveness. This was vindictive. This was meant to disadvantage one candidate over other candidates. But it must be remembered that Kasukuwere did not impose himself as a candidate. He actually presented himself before a nomination court. And the nomination court found that he qualified. And they accepted his papers only for the one guy from, I don't know, I think from ZANU-PF, who then lodged that matter in the High Court. It was wrong.